Hello and welcome back. Today we'll be starting with Article 20. We had already covered certain articles in fundamental rights, right from Article 12 to Article 19. And the subject matter for today is Article 20, which is about protection in respect of conviction for offences. I request you to please open the Bare Act and please read the content of Article 20. And if you are not having the Bare Act, then I have included the language of the article in the presentation itself. So this is Article 20, which is as mentioned in the Constitution of India. Now it says in clause 1 that no person shall be convicted of any offense except for the violation of law in force at the time of the commission of the act, nor be subjected to a penalty which is greater, which might have been inflicted under the law in force at the time of the commission of the offence. Clause 2 says that no person shall be prosecuted and punished for the same offence more than once, and clause 3 says that no person accused of any offence shall be compelled to be a witness against himself. So these are the three clauses that are included within Article 20. Now let's see in some detail that what is the plain and simple meaning of the three clauses. Now if somebody asks you that what is essentially the subject matter of Article 20, and then you can provide the answer by quoting these 3 points, that the three clauses of Article 20 essentially they deal with the first one, that is ex post facto laws, second, double jeopardy, and third, prohibition against self-incrimination. Now what is the meaning of ex post facto law? Ex post facto law means such a law or a law which has been implemented from a back date. Suppose a law is enacted, a law has been made today, but if the government notifies that law, if the government says that law will not be implemented from tomorrow onwards, but it would be implemented from day before yesterday onwards, then that particular law will become an ex post facto law. So Article 20 in a way prohibits ex post facto law. Now this clause, this provision regarding ex post facto law, it has an element of similarity with the American Constitution. You see, in the American Constitution also, in Article 1, and then under Article 1, sections 9 and 10, they also have the same or similar kind of provisions which are related to the prohibition of ex post facto laws being made. Accordingly, in America, such a law cannot be passed. Section 9 says that the Congress, the central legislature, the federal legislature in America, it cannot pass ex post facto laws. Likewise, Section 10 says that the various states in America, the state legislatures of the various states in America, they also cannot make ex post facto laws. And what is ex post facto law? Broadly speaking, an ex post facto law would be one which punishes something which when done was legal. As I said earlier, let's try to incorporate this point also in that example. Suppose day before yesterday committing murder or killing somebody was not a crime. Again, it is a hypothetical scenario, but please try to imagine it, that suppose day before yesterday killing somebody was not considered as a criminal offense, and today the parliament has passed a law and which says that killing somebody would be a criminal offense. Now what will happen to all those people who had killed someone day before yesterday? Can those individuals be prosecuted under the new law? And this is the point with respect to ex post facto laws, which says which means that such a prosecution cannot take place, meaning thereby all those people who had committed murder, who had killed somebody day before yesterday, cannot be charged, cannot be prosecuted under the new law which has come today. That is the meaning of ex post facto law. In other words, such a law would declare a conduct as criminal in retrospect or from a backdate, meaning thereby, with respect to criminal legislation, with respect to criminal matters, retrospective effect to the law cannot be made. Excuse me. It is this feature of the law making process which is aimed to be prevented by the language of clause 1, and this I hope is now abundantly clear. But please understand that this limitation regarding ex post facto laws is only related to criminal legislation, is only related to criminal matters. But if a law comes into picture which places a civil liability, which imposes a civil liability can be the imposition of a fine, the imposition of a monetary fine. Now if a civil liability is imposed, then can that civil liability be made retrospective, can be implemented from a back date? And the answer is yes. So a law which imposes a civil liability can be given retrospective effect. Therefore we see that there is a distinction between the types of wrong behavior or bad behavior. One distinction or one thing is criminal matters, and the other is civil matters. Ex post facto laws cannot be made with respect to criminal matters, but ex post facto laws can be made with respect to civil matters. Imposition of fine, monetary fine, can be done because it would be a civil liability, but criminal liability cannot have a retrospective effect. Now if you read clause 1 further, then the second part of clause 1 says that no person should be subjected to a penalty greater than that which could be inflicted under the law in force at the time of the commission of the offense. What does this mean? It means that if for a particular wrong behavior, if for a particular negative behavior, bad behavior, the punishment is say 10 days of imprisonment or 500 rupees of a monetary fine. Let me repeat this thing again, that if for a particular wrong behavior, if the punishment is 10 days of imprisonment, or for that, or there is a monetary fine of rupees 500, and suppose that individual committed that wrong behavior, showed that wrong behavior, then can the individual be punished more than the quantum of punishment that has been defined in the law? And the answer is no, meaning thereby the maximum punishment which can be given to that individual would be, in our example that we have taken, would be 10 days of imprisonment or the fine of rupees 500, meaning thereby the courts cannot send that individual to prison for 11 days or for 12 days for that matter. Also the courts cannot impose a fine more than rupees 500. So that is the limitation. So second part of clause 1, that no person should be subjected to a penalty greater than that which could be inflicted under the law which is in force at the time of the commission of the offense. In other words, the punishment of the crime could not be disproportionate to the crime itself. The punishment cannot be more than which or what has been prescribed by the law. And there is an interesting case that has come into picture, and that is Kedarnath Bajoria versus the state of Bengal. And this second point, or the second part in clause 1 has been explained by the courts in this particular case. Now what was the background of the case? Here this individual, the accused, committed an offense in 1947 under an act which described the punishment of imprisonment or fine or both, and the individual had to go through this punishment. Now what happens, that the law itself was amended, and what was done, that the quantum of fine or the amount of fine was enhanced, and the amount of fine was made equivalent to the amount of money that was found on that individual who is the offender who has committed the offense, the amount of money which that individual has procured through the offense, so the amount of fine would be equal to that. The courts held, now what the authorities wanted that Kedarnath Bajoria should be you can say should be prosecuted or should be punished according to the amended act. But the court held that the enhanced punishment prescribed by the amendment could not be applicable to the offences which are committed in 1947. Why? Because of the later part, because of the second part, which is in the clause 1 of Article 20, which says that the crime and the punishment for the crime should be proportionate. They cannot be disproportionate, because the provisions contained in the later part of Article 20 clause 1. But please understand that penalty cannot be enhanced, and that enhanced penalty, or you can say punishment, cannot be given according to the enhanced penalty. But at the same time, if the amendment wants to reduce the liability or the penalty, then that can happen retrospectively. And this is an important point with respect to Article 20 clause 1, that there is no prohibition with respect to the reduction of penalty retrospectively, meaning thereby if the penalty today for a particular wrong behavior, for a particular wrong activity is say ₹1,000, and then tomorrow the law is amended and the penalty is reduced to 500, can this be allowed to be implemented retrospectively, that is from a back date? And the answer is yes. So this is the state of affairs, this is the situation with respect to Article 20 clause 1. Now coming to a second part of Article 20, let's go to the second part, or the second clause of Article 20. And here, before going to that second clause, this entire information is with respect to that Article 20 clause 1, which again talks about retrospective increase or decrease of liability, and specifically with respect to, or by taking into account the differentiation between criminal cases and civil cases. And there is another case of decided by the Supreme Court, that is Yogendra Kumar Jaiswal versus State of Bihar, which was related to disproportionate assets of a public servant and the confiscation of that property. So this is all related to Article 20 clause 1. Now let's move on to Article 20 clause 2. Now what does Article 20 clause 2 says? Article 20 clause 2 talks about the prohibition of double jeopardy. Double jeopardy means that a person cannot be punished more than once for a crime or for a wrong behavior, for a wrong activity which that individual has indulged into. किसी भी पर्सन को एक गलत काम के लिए एक बार से ज़्यादा सज़ा नहीं दी जा सकती. That is the basic idea. In legal sense, clause 2 of Article 20 is based on this common law maxim. From the legal perspective, the common law maxim, it is nemo debet bis vexare. It means that a man shall not be brought into danger for one and the same offense more than once. For the same offense, punishment cannot be given more than once, meaning thereby the individual committed an offense, you punish that individual, the case is closed. But if that individual is punished again, then that is not allowed. So if a person is charged again for the same offense, he can plead as a complete defense his former acquittal or conviction, or as it is technically expressed, to take the plea of autrefois acquit or autrefois convict. Meaning thereby, if a person A was charged with an offense and individual A was prosecuted, then in that case, in that prosecution, there could be two results, where either the individual can be acquitted, meaning thereby the individual is free to go, or the individual can be declared as a convict and the individual is punished. In either of the two cases, if the individual is acquitted, or if the individual is declared as a convict and the punishment and the sentence has been given, and the individual would be you can say treated accordingly. But if for the same case, if for the same offense the individual is charged again, if the individual is brought to the court again, then the individual can say that I had been prosecuted for the same offense previously, and I was given a trial, and on that basis I have been either convicted or I have been acquitted. So the basic argument is that no person can be you can say put into jeopardy, could be put into harm's way for the same offense more than once. This understanding this clause would be very easy if you all are able to recall what all experiences you have had in your childhood days. Is it not a fact that in the childhood days we all have indulged into mischievous activities, we all have committed mischief, we all have committed small mistakes, petty mistakes in the homes, but what was the situation? For the wrong activity, for the wrong act, if we were caught in the childhood days, then usually it is the mothers, the mother who would be giving the punishment. And once the mother has done the job, it used to happen that in the evening the other parent, that is the father, also used to give a good treatment for that particular negative behavior that we have displayed earlier. Now this is a classic example of double jeopardy, where for the same offense we had received punishment more than once. Constitutionally speaking, this is incorrect. Constitutionally speaking, this would not have happened to all of us, but then again Indian parenting is very different and is largely not based on the constitutional principles. I hope you are able to understand what I am trying to say over here, and with this crude example from our own past experiences, but then again making this point clear is the basic goal. And through that crude example, I hope that you are able to understand that what are the limitations that have been placed by Article 20 Clause 2, which prohibit double jeopardy. Now please understand that this provision is included in the American Constitution, also in the 5th Amendment to the American Constitution, which declares that no person shall be subject for the same offense to be twice put in jeopardy of life or limb. The individual will not be punished twice, would not be brought into harm's way for the same offense more than once. That is the basic idea. This principle has been recognized by the various statutes, by various laws in India also, and please see that section 26 of the General Clauses Act 1897 and section 300 of the CRPC, the Criminal Procedure Code, also talks about the same idea, that the individual will not be punished for the same offense more than once. Now the important term that should be noted here is the term prosecution, the term that has been used in clause 2, and that is prosecution. So what does prosecution mean? Obviously, if somebody is not to be prosecuted again for an offense for which an individual has been prosecuted earlier, it becomes important to to know, it becomes important to understand that what is the meaning of the term prosecution. Now the prosecution which is used in clause 2, it has three essentials. It should be having three inherent characteristics. First, there must be a person accused of an offense. Obviously prosecution can start when there is an accused person, and how this accused person is defined, or how that offense has been defined. The word offense will be having the same meaning as is used in the General Clauses Act, as something of an act or omission which is punishable by law for the time being in force. So prosecution, one of the essential elements of prosecution means that there would be the presence of an accused person, and that accused person would be charged with an offense. And how that offense has been defined, the word offense has been defined and would be having the same meaning as that is included in the General Clauses Act of 1897, as an act or omission which is made punishable by any law for the time being in force. So now this becomes a settled fact that there should be a person who should be charged of an offense, and then only the idea of prosecution can begin. Now the prosecution proceedings should have taken place in front of a court or a judicial tribunal. This is the other element, this is the other essential, that the proceedings or the prosecution should have taken place before a court or judicial tribunal. Meaning thereby it should have taken place, the proceedings should have taken place in that in that particular arena which is empowered to record statements, which is empowered to accept witnesses and evidence. And the forum for this would be a court or a judicial tribunal. But revenue authorities like the district magistrate, or for that matter the sea customs authorities as the example I've taken, they are not considered as judicial tribunals. Likewise, tribunals which are conducting administrative inquiries, departmental inquiries, they are also not considered as tribunals, and therefore these institutions, if a case goes to these institutions with respect to a departmental or administrative inquiry, and after that inquiry if the individual is punished, if that individual is punished by way of some things which the individual has done, now in that case that individual would not be considered as being prosecuted. So this is a second element. The third element is that proceedings should have taken place before a judicial tribunal or court in reference to the law which creates the offense. Now this is the third important essential of the word prosecution, that proceedings against that individual would be specifically related or in reference to the law which defines that offense and which gives punishment for that offense. Therefore, where an inquiry is held before a statutory authority against a government civil servant, not for the purpose of punishing for the offense of cheating and corruption, but to advise the government as to the disciplinary action that is to be taken against him, then it cannot be said that the person has been prosecuted. Meaning thereby departmental inquiries, the departmental punishments that come into picture, they cannot be said that they were the result of a promotion. So if there is a civil servant, there is a government servant against whom there is a charge of murder, then that charge of murder would be prosecuted in a court, and the department also would be taking cognizance of that, would also be coming to terms with that wrong behavior which has been committed by that government servant. And if that government servant goes through a departmental inquiry, and after that departmental inquiry, it is recommended that the government servant should be demoted from the present, you can say, post or the level in the government hierarchy. And at the same time, the court also punishes that individual for murder under section 302 and sends that individual to prison. Then the individual cannot say that I have been prosecuted, I have been punished for the same offense twice. Why? Because departmental inquiries which are conducted by authorities, by departmental functionaries, is not considered as prosecution, whereas the things which go or which happen in a court of law and the punishments coming out from that court of law would be considered as punishment and would be applicable to that individual. So these are the three essentials with respect to the term prosecution that have to be kept in mind while seeing cases of such nature. Therefore, what is the point that we can take home? The point that we can take home is summarized in a way in this small paragraph, and if you read it, that protection provided by clause 2 of article 20 is with respect to second prosecution for the same offense. If the individual is prosecuted again for the same offense, then only the individual can claim protection under clause 2 of article 20. But what if the offenses are distinct? Suppose there are two distinct offenses, then in that case the protection under article 20 clause 2, that is double jeopardy, it will not apply. Now what can be this kind of a situation? Suppose there is individual A who is having some trouble or who is having some grudge against individual B. एक इंडिविजुअल A है, उसकी इंडिविजुअल B से दुश्मनी है, and individual A says that I will kill B, I will murder B, and individual A picks up a knife and starts going or moving towards individual B, and while doing so, individual A encounters one more individual, say C. जब तो जो वो B की तरफ मूव कर रहा था नाइफ लेकर के, तो रास्ते में उसको पर्सन C मिला, and this person C tried to stop individual A, and what happens that individual A becomes angry, and first the individual A kills individual C, individual A murders individual C, and then moves forward, goes to individual B and murders individual B also. Now please see that two different offenses have come into picture, two different crimes have come into picture, murder of C and murder of individual B by person A. Now in this case double jeopardy will not apply. I hope you are able to understand through this simple and crude example what is meant by this point. So this is the basic argument with respect to clause 2 of article 20. Coming to clause 3, clause 3 gives protection against self-incrimination. It prohibits self-incrimination, meaning thereby no person can be compelled to become a witness against his or her own case. Individual cannot be compelled to give self-incriminating information to the authorities. Suppose an individual has been arrested by the authorities, and the authorities know that this individual has committed the crime, but then again the authorities cannot compel that individual to give information which would be going against that individual in a court of law, meaning thereby the individual cannot be tortured, the individual cannot be given third degree treatment by the police authorities, so that the individual gives information which can be used against that individual. against that accused. So that is the basic idea behind Article 20 Clause 3. So the clause declares that no person accused of an offense shall be compelled to be a witness against himself. Now what does this means? This provision embodies the principle of protection against compulsion of self-incrimination, and this is a fundamental concept in the British system of criminal justice. This idea has been incorporated by the American Constitution also, in the American system also. Now in American Constitution, the Fifth Amendment includes this idea also, that no person shall be compelled in any case to be a witness against himself. In India, this point has been given the status of a constitutional provision. No, this shows that what would have been the seriousness of the founding fathers of the Constitution with respect to this point, that they made this concept of a prohibition against self-incrimination, and they placed it as a constitutional safeguard. Now the Supreme Court, in this case, it is a very important case and a famous one, Selvi versus State of Karnataka. Now in this case, the Supreme Court has analyzed this concept of prohibition against self-incrimination, which is included in Article 20 Clause 3. And while interpreting the case, while interpreting the situation, the Supreme Court took into account, the Supreme Court factored the both national and international developments in human rights with respect to this particular case. And what they have found, they have found three components which are included in Clause 3 of Article 20. And what are these three components? The first component is that it is a right pertaining to a person accused of an offense. Obviously, this entire situation, this entire argument, the most central element of this entire argument would be the person accused of an offense. Second, it is a protection against compulsion to be a witness. Nobody can compel an individual to be a witness. And the third, the protection against such compulsion resulting in his giving evidence against him. Meaning thereby, there would be a person who is an accused, say individual A. The individual A cannot be coerced, cannot be compelled to become a witness. That is point B. Point number 2, I'm sorry. And lastly, the individual cannot be compelled to become a witness against himself or give evidence against himself. Now let's try to see what is the elaboration, what is the detailing. The first component is that person should be an accused of an offense, meaning thereby who can claim the protection under Clause 3. Who can claim the protection under Clause 3? Obviously, somebody who is an accused. Only an accused can claim protection under Clause 3. Now, in India, what has happened, because of the nature of the society itself, the socio-economic nature of the society itself, only the accused can claim protection under this clause. Only the accused can do so. There is something called as Indian Evidence Act, a very important piece of legislation, Indian Evidence Act 1872. It is through this act it is decided that what type of information would be an admissible evidence, and which information cannot be admitted as an evidence in the court of law. Now this law, according to the provisions of this law, only the accused can claim the protection under this clause, that is Clause 3 of Article 20. But in America, through although this this idea of prohibiting self-incrimination is included in the American Constitution, but in America this privilege against self-incrimination is not confined to the accused, meaning thereby this prohibition or this privilege against self-incrimination is available to witnesses also. Likewise, in the English law, in the British system also, a witness is protected from answering questions which may lead to criminal prosecution against that individual, against himself or herself. That is the basic idea, and that's the basic difference. Now coming to the second component. The second component is giving a protection against compulsion to become a witness. Nobody can be compelled to give oral statements or make written statements in the court which would be going against the interest of the accused, or the accused himself cannot be compelled to make such statements which would be going against his or her case. Please understand that although compulsion cannot be created on an individual to become a witness against himself or herself, but if the authorities, while investigating a matter, asks for thumb impression or the fingerprints or handwriting specimens, so on and so forth, now all these are admissible, all these are allowed. This will not be coming within the protection that is given through clause 3 of Article 20. So a person can be asked to give thumb impression, the person can be asked to give a finger print impression or writing specimen, or the individual can be asked to show the parts of body for identification. Now all these things are part and parcel of the investigative process, and all these are allowed, and the prohibition that comes through Article 20 clause 3, that is prohibition against self-incriminating evidence, this protection is not afforded to all these things. Likewise, if the court has given a warrant to search, if there is a search warrant to search the premises of a particular premises, and it has been duly issued under section 93 of CRPC, then also clause 3 of Article 20 does not extend any protection. So that is the basic idea with respect to the investigation of matters. There are certain things which are permitted, and there are certain things which are not permitted. Now the third component is the compulsion must be giving evidence against himself, meaning thereby the individual is compelled to give an self-incriminating evidence, and that is the third component. Now the point is that if the individual wants to make a statement voluntarily, if the individual wants to make a statement without any fear or favor, now will that statement be admissible, or you can say will that be allowed? Now in this case, that is Kalavati versus State of Himachal Pradesh, the Supreme Court said that Article 20 clause 3 does not apply at all to those cases where the confession is made by the accused without any inducement, threat or promise. So if the individual has made the statement of confession without coming under compulsion, without being threatened, without being induced, then in that case that statement would be considered as an admissible statement. But if the individual has been compelled to make a statement of a confession, now that statement of confession would not be considered as a valid one. Not only this, the what would be the meaning of compulsion? That compulsion itself has also been defined that what all things can be included under the term compulsion. So you see that in such a great detail, the courts in India, the judicial system in India has defined certain things, many things in fact. But then again, this process is an ongoing process. This process of defining the things, it is an ongoing process. But a very good point in this regard is that how and when it would be said that a person has been compelled. So in law, in legal profession, compulsion means something which is or someone who is under duress. So that is the technical term that is used. Now duress is a situation when a person is compelled to do an act by injury, beating or unlawful imprisonment, or by the threat of being killed, suffering from bodily harm, or for being unlawfully imprisoned. Meaning thereby, if an individual is beaten, if the individual is injured, or if the individual is unlawfully imprisoned, or if there is a threat that the individual would be killed, or the individual will suffer bodily harm, or the individual would be unlawfully imprisoned, then in these situations the individual will come under duress, and this means the individual has been compelled. Likewise, in the definition of duress will also include threatening, beating, or imprisonment of wife, parents, or the child of a person, meaning thereby threatening the near and dear ones, beating the near and dear ones, or imprisoning the near and dear ones of an individual, either actually or making a threat in that regard, also will create a duress, and therefore the individual can come under what you say as compulsion. So all these ideas are included in that third element. Now what has happened in the whole of the world, that the techniques of investigation, they have become very much modernized. With the development of advanced scientific technologies, the techniques of investigating a matter, they have also become very much modern. And examples of this modern investigative techniques, they are narcoanalysis and this brain mapping, brain scanning, etc., polygraph examination. Now the courts have appreciated this reality that yes, things have changed in the investigative sciences also. But then again, the constitution of a country is the supreme law of the land, is the supreme or the most superior law of that country, and anything which is done by the investigative authorities, or any new technique that is incorporated by the investigative authorities, these techniques also have to satisfy, these techniques also should follow the norms and the rules that have been laid down in Article 20 clause 3. So again, as I said, that Selvi versus State of Karnataka is an important case law. And why? Because in Selvi versus State of Karnataka, in this case, the Supreme Court has observed that involuntary admission or administration of such procedures. What are such procedures? Such procedures are this narcoanalysis, polygraph examination, etc. Involuntary administration, without the permission of the accused, without the consent of the accused, if the individual is placed under narcoanalysis or polygraph examination. Now that thing would be going against the spirit of Article 20 clause 3. Now that would be violating therefore Article 20 clause 3. But if these tests, these narcoanalysis tests, this polygraph examination test, these tests are administered voluntarily, meaning thereby there is the consent of the accused person, then in that case the information found would be admissible. This information that has come out through these tests would be admissible as an evidence. but at the same time the guidelines that have been laid down by NHRC, they have to be followed while conducting these tests. So this is the situation with respect to the modern day investigative techniques, that though they are modern, their technology is new, the methodology used is new, but then again the basic idea is that whether this technique which is used on an accused, which is applied on an accused, that whether that accused has given the consent or not, क्या उस accused ने उस particular technique को अपने पे use करने के लिए हाँ बोला था कि नहीं. If the individual has been administered with these techniques without that individual's consent, without the consent of the individual, then the information found through that through those tests will not be considered as an evidence. But if it is a voluntarily administered test, जो accused person है उसने इस particular test के लिए हाँ बोला था, so if that individual has voluntarily consented for that particular test and that individual is put through that test, so if whatever information that is found by the authorities can be accepted in the court of law as an evidence, provided the guidelines of NHRC are followed thoroughly. So this is all about Article 20 right from clause 1, which talks about ex post facto laws. In that ex post facto laws, we had seen that with respect to criminal legislation, ex post facto laws cannot be permitted, but civil liability can be having that retrospective effect, can be given retrospective effect. Likewise, then we went to clause 2, which was related to double jeopardy, meaning thereby an individual cannot be prosecuted for the same offense more than once. And then we saw that what is the meaning of the term prosecution, what is the essential elements of prosecution, and finally we came to the third clause, that is with respect to prohibition against self-incrimination. No person can be compelled to become a witness against himself or herself. So this was Article 20 with all the three clauses. Please try to go through this entire discussion again and try to incorporate these ideas in your brains, in your cognitive faculties, and also keep in mind one important point, that in the entire article the word used is person. The entire article, the word used is person. And what is the meaning of this word? If it is used in an article, it means that this would be applicable to citizens as well as non-citizens. So Article 20 does not make a distinction as to who is a citizen and who is non-citizen. Each and everyone is equally subject to this article, can claim the protection from this article. So this was Article 20 for you all. I'll be continuing with this line of thought, and in the next session I'll be discussing Article 21 onwards. Thank you very much.